going to get started right away. This presentation has a lot of information, and we want to try and stay as close to on time as possible. So let me get this part going here. So you are here for business. It's a business part of our Business Foundation series. It's legal issues facing business owners. It does have a counterpart, which is more legal entities. I would put that link into the chat here after my introduction so that you can register for that part if you'd like to cover that information. So you want to talk about SCORE real quick. So SCORE offers training and in the form of workshops and webinars. It's one of the things we do. We do have a few in-person workshops that we've been slowly adding. So definitely check out the newsletter or go to our website and look at the offerings we have. We have a lot of, actually, I was just talking to our presenter today about this, that we have a lot of new topics for us this year, and we're very excited to be bringing those to you. The most important thing that SCORE does is mentoring, though. Mentoring, our mentors are volunteers that have different experiences and knowledge that they want to share with you. We work with folks that are at all stages. We have those that are thinking about starting a small business, wondering if it's the right step for them. We have folks that are in that planning phase that need help putting together their business plan or have questions about what to do to get things started. And we have folks that are already in business. They might be ready for growth. They might be needing assistance with, marketing or accounting or any of the various types of business questions. And you usually have someone within our district that can assist you. And if we don't, we can reach out to the national database to try and find somebody that can answer those questions. But usually we can find somebody locally to help you. That first mentoring session is kind of get to know you. They want to know about you. They want to know about what your goals are. And we'll start to help formulate a plan. Sometimes you'll even get a little bit of homework. But it's about, getting that plan made so that they can work with you step by step to get you to that goal. Sorry, give me 1 second. Sorry about that. So if you are interested in a mentor, it's very easy. You can put a little note in chat and I'll make sure the right chapter reaches out to you, or you can go to the website, the actual district websites here, or just go to the score.org website, either one. And they will connect you to your chapter. While you're there looking for that mentor, you can also check out the library section. There are tons of blogs and templates and all kinds of information in there that you can also use that I think anyone would find useful. We usually do have quite a few questions with this presentation. So we are definitely going to be very strict on this. If you have a question for our presenter, please put it into the Q&A tab. Everything else can go into chat. If you put your question in chat, I might not see it and it might not get asked to the presenter. So please try and use that Q&A tab. Also, if there's a follow-up to a question you post, if you put anonymous, it's difficult for me to link those questions together, because sometimes we need to ask you a question to answer your question. So consider leaving your name just so we can keep those questions organized. Okay, and we are recording today. I won't necessarily be sending out a separate follow-up email, but I will put the link on where to find that information in about, within the next 24 hours so that you can watch the recording of today's presentation. Let me go ahead and bring this down so we can give our presenter a chance to get his presentation up. So David Berman is a SCORE volunteer for us here in Boston. And like I said, this presentation is chock full of just tons of fantastic information. So it's all yours, David.
Thank you very much, Teresa. Glad you all could make it today. Feel free to ask as many questions as you need to or want to. The interchange between us usually raises a lot more specific questions that may be on your mind than the general discussion I'll give. Now, having given this previously, it tends to run long, so I'm going to try to cover everything within the hour, including getting your questions. Obviously, if it runs over, I'll be here, but I know you all have schedules to make. The important thing, though, is that, I'm just giving you some general thoughts and not legal advice on any specific situation. If you have specific legal questions, you should contact an attorney regarding your particular business. If you don't have an attorney, SCORE has resources where others have recommended attorneys that have helped them in their small business, and we could share those names with you if you wish. But let's get into the substance here before too long. And so the first thing that we wanted to talk about was licensing. Certain businesses require either state or local licenses or permits. For example, if you're a professional, a doctor, a lawyer, you need to get a license in the state in which you're doing business to operate. These are state requirements. In the professional case, obviously, you need to take an exam and meet some other qualifications. But there are other people that need licenses other than just those professionals, like massage therapists in some state need licenses, electricians, plumbers, architects, so on and so forth. If forming a company to take people on fishing trips, you'll need licenses as well for that. If you're in real estate, you'll need to go to your local authorities if you need to get any variance from the zoning requirements, or if you're building near a wetlands or the like. So, there are various licenses you may need depending upon your business. And, we can't get into each and every business, but it's important before you say you're going to operate a business, you check the state and local authorities to make sure that you don't need to be licensed. If you're, one other that I'll mention is if you're selling at wholesale to a retailer, you could get a resale license from the state so that you don't have to collect sales tax from the retailer, because the retailer will ultimately collect it from the consumer. So, as you're setting up your business, it's always wise to take a look at the state and municipal requirements so that you don't run afoul of the business. There have been, being a lawyer, there have been many cases about people conducting the unauthorized practice of law. These companies have set up closing agencies to assist you in your real estate acquisitions, and they weren't lawyers, and they got into some trouble for not having the appropriate licenses. So it's important you check this out before you actually engage, to make sure there's nothing specific you need from the state or town. Now, most people, although not as many as before, because people are operating from their homes, especially startups, but a lot of people need to get a location to operate their retail store, their manufacturing business, their personnel company, whatever it may be. And there are obviously many provisions that are going to be contained in the lease. And I've tried to highlight here the important ones to consider when you're thinking about entering into a lease for a premises. The first one, of course, is what any real estate person will tell you: location, location, location. How visible is the location if you're a retailer? How much parking is there if you need people to come to your place of business, whether it be an attorney's office where clients are coming in, or a retail store, or whatever? What is the competition? If you're opening a Burger King, you probably don't want to open right next door to a McDonald's. So you need to examine the location to make sure that you have appropriate facilities for yourself And location can include the right to expand the space. So if you have a small business and you want to rent 1,000 square feet, but as you grow, you don't want to relocate and the landlord has other space available in the building, you can negotiate with the landlord for expansion space to be exercised at certain times. So it's sort of like having a vision for your business, knowing what you're going to need. You could have a perfect location, but no parking, so nobody can get to you, so nobody comes to you. So that's the first thing, which really isn't legal. It's more of business, but a key thing to think about. You'll hear the term triple net lease or a net lease. What that means is that you're going to pay the landlord a monthly base rental of whatever the dollars are per month, in addition to which you will pay your share of his real estate taxes, his common area charges, if there are any, and his insurance and certain other expenses. So for example, were you to lease space at the Prudential Mall here in Boston, you would pay, just to make up numbers, $1,000 a month for the landlord for your space. But in addition, you would pay a portion of the real estate taxes, the maintenance for the, keeping the hallways clean and accessible, the elevators in working order, and so on and so forth. So the real cost is you have to figure not just the base rent, but all these other charges. And there are a couple of ways that it's done. There's one way is that the landlord says, let's just assume it's a 10,000 square foot building and you're renting 1,000 feet. So you're taking 1/10 of the space. So you'll pay 1/10 of the taxes, insurance, and other charges. Another way to do it, which may be a little more favorable to you, would be to set the year that you're leasing the property as the base year. So that if you're leasing it in 2023, you say, I'll pay 10% of any increase over what you paid in 2023, because presumably your base rent is covering what the landlord knows his expenses will be. And so if his taxes, for example, go up next year, you'll pay 10% of the difference as opposed to 10% of the whole tax bill. That would be a more favorable treatment to pay any increases from when you rent it. Not all landlords are willing to do that, but you need to fully understand all of the rental obligations when making the lease decision. Then we also need to consider, are you going to be a tenant at will, or are you going to have a lease term? A tenant at will basically means you're there on a month-to-month basis. You can terminate, or the landlord can terminate on 30 days notice, so that if you are at April 1st, for example, you could give the landlord notice that as of May 31st, you're out, because you have to give a full rental period if you're giving the notice beforehand, and the landlord could kick you out on May 31st. So that takes away some certainty in terms of your use of the premises. At the same time, it doesn't lock you in forever there. Most clients will try to opt for a term where the landlord agrees they can use the space for a certain number of years, as long as they don't default in the lease. What I like to recommend, especially to newer businesses, is that they try to lease for a shorter term and have the landlord give them options to extend, so that you'll have a choice. Let's say you give a 3-year lease with your landlord, and the landlord gives you 5 options to extend for another 3 years each option. So that's another 15 years you could do. But rather than being committed to the whole 18 years at the outset, you're committed to 3 years, and within 6 months before the end of the 3rd year, you could say to them, I'll stay for another 3 years, or you can say no. So it limits your long-term exposure, and you get to make decisions along the way, whether the premises is good for you. You may want to move because it's too small, or it's not in a good mall, or you may not want to move. You may want to stay there, but you don't want to make that commitment up front because you want to see how the business is going to go, whether you're going to be profitable. So I would recommend a short term, meaning 3 or 5 years, with options to extend that you can exercise during the course of the term. You're coming into a space, some space may be as is. So what you see is what you get, but sometimes you want to go in and you need to do some construction. For example, if you just have a vacant space, you may want to put up some demising walls so you can have 4 or 5 offices in the space. You may need to put a bathroom in the space or whatever. So you can negotiate those costs with the landlord, agree with the landlord on what changes are to be made to the space and which ones the landlords are going to pay for and which ones you're going to pay for. A lot of times landlords will agree to pay to repaint the premises or to add a bathroom or something, but you need to look at the space, sort of have a floor plan, figuring this is what I want it to look like, and then negotiate with the landlord for him to pay these things. Now, that being said, even if the landlord pays up front, he'll probably get some of it back through your base rent over time. So instead of charging you $1,000 a month, he may charge you $1,100 a month, but he'll put up the upfront costs, which is very important when you're starting a business at a new location. You also need to understand any use limitations that may be in the lease. Landlords will typically say that you can use the premises for a specific purpose. Let's just say, for ease of reference, a law office. And let's assume that your law business doesn't take off, but you want to change the use of the premises to something else. Your lease may not let you do that without the landlord's consent. In addition, there may be use limitations in other leases that will limit what you can do. For example, if you're in the Prudential Center and you want to open a Walgreens, there is a CVS in the Prudential Center, and CVS's lease may say that the landlord agrees not to rent to anybody else who's going to have a drugstore. So you may not be able to use the property for what you want. Similarly, if you get big enough, you may be able to say to the landlord, I don't want you to lease to anybody else who's going to be in a competitive business. But I think for small businesses starting out, you more have to worry about, are you restricted in any way in using your premises? The leases can also have your right to purchase the building. I have a client who leases a restaurant in a building, and we've built into their lease that at a certain point in time, they can purchase the building at a certain price. Depending upon your premises and what you view your business as, you could negotiate with the landlord to say, at the end of the lease, I'd like to buy this for X dollars, or it could even be, I'll buy it from you for whatever the market is at the time, but that would sort of give you the right to take over the building. Think of it as sort of a car lease. Your car lease ends, you can either turn in the premises, or you can turn in the car or buy the car. And this is sort of what we're saying here is your lease is coming to a close, or at some point in your lease, you can buy it rather than just vacating the premises. Now, what happens if your business gets into trouble and you want to get out? There are 2 possibilities, at least. One is you could try to find somebody to take over your lease. The landlord generally will put in there that you can't have somebody take over the lease without his or her consent, because they want to know who they're doing business with. So that if you wanted to transfer your lease to me, they want to know who I am, what my financial wherewithal is, and that I'm going to be able to perform under the lease. They may also, if you're a law office and you want to transfer it to me to be a car dealership, they're going to want to, make sure that the use fits in with what they want. So most of the leases will provide that you can't transfer the lease to anybody else without the landlord's consent. If you can get a lease without that, that makes it all the more marketable and valuable. If you can't assign the lease, then the landlord has various remedies. They can give you a notice to evict you, and the key thing is that any of your failures under the lease should have some sort of a grace period, so that if your rent is due the first of the month and the payment comes in the second of the month, you don't want the landlord to say you're in default, I'm throwing you out. So you would want to put something in there that says if you don't pay within 5 days, 10 days, with the maximum that you can get when due, it's a default, so that you have a grace period so you don't hiccup by being 1 day late. Similarly, if there are non-payment default issues, for instance, that let's assume you put a sign up and the lease prohibited you from putting a sign up, or you fail to shovel the walk from snow in front of your building, and that was an obligation under the lease, you wouldn't want the landlord to immediately throw you out. So you'd want to be able to get a notice from him saying, you know, you're in violation of lease because you didn't do this, and you better fix it within, you know, try to get 30 days, but at least 15 days, so that you can cure some of the things that that may give the landlord the right to evict you. If notwithstanding having those cure periods in your lease and you still fail to comply with the lease after those periods, the landlord will be able to evict you through a court proceeding. Two things you may want to think about in terms of the lease. Number one is landlords also often put in the lease that if they default you, all of your rent becomes due. So what that would mean, let's assume you have a 5-year lease and in year 2 you default, that would mean that the landlord could sue you to collect not only what you owe at the time you default in year 2, but to collect years 3, 4, and 5 as well. It's called an acceleration clause. That I would try to resist and tell the landlord, you know, yes, you're on the hook for the rent, but only on a month-to-month basis. Because the second thing you want the landlord to agree to is that he or she is going to go out and try to find somebody to take over the space. And if that somebody takes over the space, then what you owe should be reduced. So that if you're paying $1,000 a month and the landlord gets me to come in and substitute for you, and I'm paying $750 a month, then you should only be responsible for $250. Or if I come in and as the market is now, you know, very high, and I'm paying $1,500 a month instead of $1,000, you shouldn't have to pay the landlord anything from that point forward. So we do want the landlord to have to go out and not just sit there and count on you to make payments or look to you for payments, but they have to affirmatively take action to try to get a replacement tenant, so to minimize his loss and your loss as well. Subordination and non-disturbance agreements, I get a lot of questions about what are these. That's why I put it in here. What this generally is, the landlord has a mortgage holder, and the mortgage holder wants to be able to foreclose on the premises without your lease. So typically, they would foreclose. Your lease would be terminated if you were subordinate to it. But what the tenant gets in return is an agreement from the landlord, from the mortgage holder, which is binding on future owners, that says, notwithstanding that I can extinguish your lease by foreclosure, as long as you're in compliance with the lease, I'm going to let you stay there for the rest of your lease term. So the landlord gets what it wants, which is legally its mortgage can extinguish your lease, but they've agreed that they won't extinguish your lease. So it's legalese that mortgage holders like to have, but you have to make sure that if you sign something, you get a non-disturbance as well, so that if the landlord defaults to the bank sells the property at foreclosure, you still can occupy the premises. And I say last, this is just one of a myriad of provisions. You'll see leases that go 5 pages, and I just had one I reviewed that went 50, 60 pages. Which was overkill. But force majeure means if something happens, an act of God, then your obligations under the lease and the landlord's obligations under the lease are suspended. So, for example, if there was a war and the fighting was in Boston, your obligations would be suspended. But what this really became relevant was during COVID, because people, you know, couldn't go to their offices, weren't supposed to, they couldn't conduct business, and they wanted some rent adjustment or rent forgiveness. And most of the leases didn't deal with force majeure in terms of COVID. And in addition, the force majeure clauses said that even if you don't have to comply with everything, like be open for a certain number of hours and so on and so forth, you still have to pay me the rent. So you wanted to negotiate something in your lease so that if there is another pandemic or something else that prohibits you from using the space as you intended to because the government says you can't or somebody else says you can't, that you don't have to keep paying rent to the landlord. As I said, these are a few of the myriad of things that will come up when you're talking about leases. Moving to other contracts, one that most of you have will be employment contracts. Many of your employees will be at-will employees, which means you can terminate them at any time with reason or without reason. So that, you know, I'm working for you and 3 weeks in, you say it's not a good fit. You say, you know, it was nice working with you, you're gone. You know, we generally counsel clients at SCORE, you know, to use this at-will provision in a smart manner so that they don't get sued. For example, I have a client I recently contacted me who was having an employee that was causing an unhealthy work environment and asked for certain things. And if you just fired this person, she may make a claim that you were retaliating against her or discriminating against her for some basis. So we came up with a plan while she was at will to basically, you know, give her warnings and notice, to build up a file that she was a bad employee so that we could fire her and at least have a record, as opposed to her being a litigious person coming back at us. So a lot of your employees will be at will. You could hire an employee for a term, which means that you'll give somebody a contract for a year or 2 years or whatever it may be. Obviously, this would be somebody who's more of an executive or a key employee than you know, someone who works in the copy center or something like that. So, and you know, for that you have to think about how long do you want to basically guarantee them their employment. You can still terminate them for cause, but you can't just wake up one morning and say, you know, you haven't done anything wrong, but I don't want to work with you anymore. They'd have a term, you'd have to pay the rest of the contract. A lot of our clients try to start off by using independent contractors. The difference between an independent contractor and employee is severalfold. First of all, with an employee, you'll withhold Social Security, you'll withhold federal and state income taxes from their paycheck, and you'd have other obligations. An independent contractor, you just pay a fat sum and they deal with their own taxes and Social Securities. Perhaps think of it this way. If your toilet is plugged, you call a plumber, he comes over, does the job, you pay him a fee, he leaves. You don't worry about, you know, paying for his insurance. You don't worry about giving him any vacation time. You don't worry about paying him, paying for his federal taxes and the like. So that would be an independent contractor who basically is someone who's employed to do a specific project, a specific job. You give them a specific sum of money, and that's it. They're on their own. They really, you know, aren't under your control. For example, if I were an employee, you could say to me, you know, your hours are 9 to 5, Monday through Friday. You have to wear a suit to work every day. You know, you have a half hour for lunch. You know, with an independent contractor, none of that. It's like, I'm hiring you to do this job. I'd like you to do this job. And he comes and he does the job, but you have no control over when or how he does it. And as I said, that's a way that a lot of clients try to start out. Rather than bringing people on as employees, they hire them as independent contractors, and many times they will become an employee afterwards. Remember also, an independent contractor, you know, that plumber can go to 25 houses in a week. He's not beholden to you, as opposed to an employee who presumably during his or her required work hours must work for you and can't be doing 2 other jobs. Other items that come up in a employment situation is non-competes. Non-competes are generally not favored by most states and most courts because it impedes somebody's ability to earn a living. So, for example, if you wanted to have all your employees sign a non-compete, which is what a lot of employers do, that probably wouldn't be enforceable against the person working in your copy center. You know, that just would be unfair that he couldn't go out and get another job in another copy center. But that non-compete can, in certain circumstances, be enforceable. You know, if it's like an executive, if you're talking about your chief financial officer, you could have a non-compete with him that prohibits him or her from going to another company in a similar business in a similar fashion. So if you're a construction company and you have a chief financial officer, you may not want him or her to go to a different construction company in the same city to act as their chief financial officer and bring all the knowledge he has about your billing practices, your pricing practices, and the like to somebody else. The key thing in structuring a non-compete, in Massachusetts, you know, a couple of years ago passed a very detailed law on, you know, what has to be in a non-compete or not in a non-compete, but basically focus on the geographical location and the time period. So if you're a local business in Massachusetts, let's just say it's a construction company based in Massachusetts, all your jobs are in Massachusetts, and you know, your chief financial officer wants to go to California with his family and work for a construction company there, it probably wouldn't be reasonable for you to say he can't work in California because they're not going to be competing with you. They're not going to be taking business from you. So the geographical location is important in terms of the non-compete. Now, there can be circumstances where the non-compete is a nationwide non-compete, depending upon the nature of your business and clientele, you know, especially with some, you know, internet businesses now, B2B and B2C. But the first thing is try to limit the geographical territory as much as possible. The second thing is you can't have a forever non-compete. You know, many businesses have non-competes of 6 months or a year, and after that they can go into another business and you know, competing business. But you can't say you'll never go into the construction business ever again in Massachusetts. That isn't going to be enforceable. Other ways to protect yourself, though, are through non-solicitation and non-disclosure agreements. A non-disclosure agreement basically says that the information you're gaining on this job is confidential information, and it's our business secrets, and you can't go using those business secrets for any purpose other than for performing your duties in our company. Now, there are some exceptions to that. Obviously, if this employee gets subpoenaed to court to testify, you know, they're not going to be able to hide behind the non-disclosure. In addition, you have to make sure that it's really confidential business information. If you know, there's an article published on the same subject in the you know, Forbes magazine, it probably isn't your business secret. It's you know, public information already. So there are exceptions to non-disclosure, but basically you want employees to agree that the information they learn about your company, whether it be the technological information, whether it be your pricing policies, whatever it is confidential, and they're not going to use it otherwise than to performing their job duties, and they definitely aren't going to share it with other people. The non-solicitation is a different animal, which is also protective of you, which is that I'm leaving your company, but I've agreed in my contract that I'm not going to go out and solicit your customers to come to work for me, to come to me and have me perform their job. So that if you're a contractor and you have a contract with, landlord X, and you do all of his construction, and I decide I'm going to form my own construction company, the non-solicitation would say, I'm not going to go to landlord X because that's your customer. I'm not going to steal your customer, at least for a period of time, I won't. Now, that works, sometimes there's a problem in proving this, because the question is if while at your company, I was the major contact for landlord X and I leave, landlord X may say, I want to come with you. So I haven't solicited landlord X. He just says, I like working with you. I'm going to come with you. So it's not full protection, but it does help. And similarly, you may not want me to leave and take 10 of your key employees to come work in my new company. So the non-solicitation would say that you can't, solicit my employees for a period of time. And of course, you have the same problem there. Who's to say, well, I went out and said, will you come with me? Or they said, can I come work with you? But having non-solicitation agreements is beneficial. I also recommend, as you grow and have employees, that you have an employee manual that sets forth the various terms of employment. It will set forth that they're an at-will employee. It will talk about vacation policies. It will talk about, work hours expected. It will talk about benefits, if there are benefits to be included or no benefits to be included. It will talk about how to complain about harassment, whether it be sexual harassment or other on-job harassment, the policies to go through that, and so on and so forth. So you can lay out basically the terms of employment, dress code, if there is a dress code, cell phone reimbursement, whatever it may be, in an employee handbook, which sets forth all of your company policies that you give to the employees. And, they sign off saying they've received them and they're bound to them even as part of their contract. And so, as I said, if you're just starting out, you probably don't need that because you're probably the only employee. But as you grow, you'll want to have a policy manual that you can refer to, so that, if there's ever an issue, you can say, look at page 22 where we said you couldn't do that, or you could do that. There are conflict of interest situations. One that I've counseled people on lately has related to, I'm working for X company and I'm trying to develop some software in my own company. The software could be used by company X. Is that a conflict of interest? So you'd have a conflict of interest policy and how to handle that internally. This one talked about, bring it to your superior's attention and so on and so forth. So policies are important. Vicarious liability, I just mentioned that because if you have a salesman on the road and the salesman makes a deal to sell 100 widgets to a customer for $1 a widget, and you want them sold for $2 a widget, you may be bound by what that salesman said, even though there may be an internal policy that says he had to get approval for any sales over, 50 widgets internally, or any price deviation or whatever, because, he's out there representing the company. Similarly, if he is driving a UPS truck for UPS and he gets into an accident, it's not just him that's going to be responsible. UPS would also be responsible because he's their agent or employee. So you need to be aware of that, and that, obviously, as you give people assignments and judge their performance and comfort with them, you have to remember that they can do things that could make you or your company personally liable. Other contracts, other than employment contracts, these items are things that that I like to see in most contracts. Number one is services. be particularly specific about the services you're rendering or that you're expecting someone to render to you. Don't just say, consult with me on my business. You know, put down specifically, consult with me regarding the development of a financial system for the business, or consult with me in setting up my QuickBooks account and implementing QuickBooks. Be as specific as possible. You can always add to that in such other tasks as we may agree, but at least for the first task you're hiring somebody for, or that you're being hired for, be as specific as possible so there's no dispute in terms of the scope of your services, because you can get into a fight either if you're hired or you're hiring somebody saying that wasn't what we originally talked about, and you want to be specific as you can. Payment terms, you know, are you going to get a deposit up front? Are you going to get paid periodically? Are you going to get paid at the end of the job? What are your payment terms? If you're not paid, you should be able to collect interest and late charges, or pay interest and late charges, depending upon which side of the contract you're on. You know, if you have to hire a lawyer to enforce the contract, you should get the lawyer's fees paid for. You know, if you're in a service business and say you're doing something at $100 an hour, you don't want to be locked into that $100 forever. You want to say something that your hourly rate changes every year, you know, on the January 1st of each year, and they'll be bound by that change unless they notify you that they don't want your services at that rate. But, you know, payment and terms are important to put in all the contracts. Exclusivity, you know, you don't see that as often, but for example, if I'm a vendor and I'm having a manufacturer make my couches for me, and you know, maybe it's an exclusive contract that the only person I'll use is you as the manufacturer to make couches for me, and you know, I'm not going to use anybody else, and for that they agree to, you know, give you a price break, or they agree to something else. You know, similarly with the exclusivity contracts, there may be certain minimums you require. So you can't say you're my exclusive manufacturer, you're going to give me the lower price, and I'm going to order one couch a year. It may be that you have to order, you know, one couch a week to get that benefit. So exclusivity can be in contracts, not as common, but in some contracts, there can be exclusive providers, and you need to think about what does that do for pricing and what requirements do you want to be exclusive provider. Warranties, you know, most of the time you want to say that there are no warranties as to the services rendered or product granted, product sold. I have a client now who provides educational consulting services, and we worked up a warranty that says, you know, I'm not guaranteeing that your child's going to get in any particular college at any particular time or any particular program. I'm just giving you my best advice. If you're selling a product, you want to say, you know, you're buying it as is and where is. You're deciding that this is fit for the purpose that you intended. I'm not guaranteeing anything. Now, there can be certain guarantees, warranties that, you know, for instance, you buy a car and you usually get a warranty from the manufacturer and the dealer that, you know, your engine won't go down for 3 years or something. So you can express certain warranties and be specific, and then say beyond that, there are no other warranties or guarantees I'm giving you. Indemnification would be something to the effect that, let's just take my educational consultant again, and he or she gets sued because of something she did, you know, advising the client should hold her or him harmless, so that she should only be responsible for anything she does. Generally, we put an exclusion saying, unless it's intentional. So for instance, if she, you know, takes a bat and bangs the client over the head with the bat and causes injury, well, then she shouldn't be protected. But if she's doing her job and it results in her being sued, it should be the client's responsibility to cover the cost of the suit and any loss that she suffers as a result of the suit. limitation of liability. Your contracts should consider having a provision that says that you're not liable for any unforeseen or special damages, but also it could say that the damages that someone can recover are limited. I personally am not fond of this clause as the recipient of the services, so that if I pay you $1,000 to fix the brakes on my car and you don't do it properly and I get into an accident and suffer severe injury, I don't think I want to be limited to recovering the $1,000 from you. But that's what a lot of contracts say. The contracts say that you can't recover from me more than what you paid me. I think that's obnoxious and outrageous, but it's in a lot of contracts. And so if you're doing a contract, you might as well try to get that through. And the last thing you need to consider is dispute resolution. Do you want to go to court if you're in a fight? Do you want to go to mediation, which is non-binding, but it's just somebody sits down and tries to bridge the gap between the two of you? Or do you want to go to arbitration, which can be binding? It's just not in a court. It's an arbitrator. There's the American Arbitration Association. It can appoint arbitrators who will hear both sides of the story and make a decision that's binding, as opposed to the court process, which will take a longer time and could be more costly. At this point, Teresa, do we have any questions?
Yeah, sorry. Yes. I do have some questions about employment. Is it okay to hire employees if you're a sole proprietor?
Yes. Yes, that's not a problem. They would be your employee. You would personally be responsible for their wages and withholdings and so on and so forth. But yes, many sole proprietors have employees.
Okay, and I think given when this question popped up, I think they're referring to an employment contract. How do you be specific when turning a volunteering service into a government contract within the scope of a practice?
Can you repeat that, because I think I missed something in the interpretation.
Yeah. How do you be specific? And like I said, I think this is about. Oh, she followed up with medical services provided. Okay. How do you be specific when turning volunteering services into a government contract? And then her next chat says medical services provided, medical services rendered into negotiating a contract. Okay. I wonder if I should go ahead and unmute this person and let them explain better.
Yeah, that would be good.
Would you be willing to do that? Can you put into chat if I can unmute you so that you can ask your question? Okay, great. Let me grab that real quick. Yep. Give me 1 second to open that screen. Okay, you should be able to hit unmute and go ahead and ask your question. Oh, we're getting feedback. We can't hear you. We can't.
Hello?
Yes, go ahead.
Okay. All right. So my name is LaQueen Battle. I run a nonprofit here in Boston called Battle First Aid Responder Services. And sometimes during the holiday, especially during the holiday season, I provide like volunteering services to Boston Logan Airport. And so I've been doing it for the past 2 years now, especially when they have flights that are delayed. This past holiday season, they had about 100, 200 flights that were delayed for about a 2-week time. So I was just wanting to know, as well as all the other volunteering that I do in the community, the city of Boston and different cities, how do I turn these specific volunteering services that I've rendered, and everything has been published on social media, it's on TikTok, it's on YouTube, about the services that I've done. How do I turn this, because it has to deal with a legal entity, okay? Mm-hmm. How do I turn these medical services into negotiating some kind of temporary contract or negotiating some kind of contract with a government entity like an airport, or like even the MBTA, or even a big, large government entity?
Right. I mean, what you need to do is you need to find the
I'm
right.
sorry, I can't hear you.
Okay. You need to find the right person in the government to talk to, because the first thing is to get into the right department and the right person.
Oh, here, I'm gonna have to, I had to pull off your, go ahead, and now you should be able to speak and she can hear you better.
Okay. You have to find the right person in the government. Usually the government, when they're doing a contract, will put out a request for proposal and people will respond to that. There are certain contracts, below a certain amount where they don't necessarily have to go through that process, but you need to get to the right department and the right person with authority to talk to them about the contract. Government contracts are a different animal than, a contract between you and me. So I think that the first thing to do is to, you must have the contacts who you deal with when you volunteer. I would approach them and say, who's the right person to talk to about getting this on a contractual basis, and what are the processes, because the government will have all sorts of regulations, that you have to follow, and forms you have to file, and things, and I's they have to dot and T's they have to cross. So I think if you get the right person in the agency, whether it be the, MBTA, the Port Authority, TSA, whoever it may be, you need to sit down with them and, walk through the process. They may not want a contract. They may just be happy with you volunteering. But you need to talk to the right person to get the process rolling. Once they agree to the contract, it's just going through the departmental regulations and making sure the I's are dotted and T's are crossed.
This one's going back to the rent and lease information. Can you explain the point about base rent to increase rent in the triple net lease topic?
All right, let me, I think I understand. The base rent is what you pay monthly. So if you come into the premises and the landlord says, I'm going to charge you $1,000 a month or $12,000 a year, that's your base rent. You pay that regardless. That's fixed. That's a fixed number for as long as you've agreed to that. The number that is called additional rent would be in addition to that $12,000 a year. You're going to pay a portion of the taxes, insurance, maintenance charges of the landlord. So if the landlord's taxes, insurance, and maintenance charges are, let's just call it $50,000 a year, and you're occupying 10% of the space in the building, you'll pay an additional $5,000 to the landlord. That won't be paid monthly. That will be paid, well, I won't say, generally it isn't paid monthly. Sometimes it is. Sometimes the landlord takes, if you're paying another $5,000, sometimes the landlord will say, you pay me the $1,000 a month plus, 1/12 of the $5,000 every month. Or it may be that you pay it once a year. But so your total expense would be the $12,000 for the base rent plus $5,000, which represents your share of the other expenses that the landlord is passing on to you.
Did you want to do your last slide and then we can go back to questions?
Sure. Slide. Okay. All right. I see we're coming up to one, so I'll try to be short-winded here. Intellectual property. You may have a mark or a logo or a patent or a copyright you want to protect, something you want to protect. If a mark could be something like your name, like let's take McDonald's. Big Mac is a mark of theirs. You may have a logo that you want to protect, like if you ever look on television, Major League Baseball has a logo that they protect. So these can be protected. federally, which gives you protection across the United States by filing an application with the United States Trademark and Patent Office. You can actually do a search on the website of the United States, uspto.gov would be the site. And you can see if somebody else is using the name or the logo that you want. And, it's not a difficult process to file for the trademark protection. And that will protect you from anybody else using that name or that logo across the United States. You could also file in Massachusetts, but that just gives you protection in Massachusetts, which really isn't the protection you want, because that means somebody in Connecticut could use the same name and the same logo of someone in New Hampshire. You'd want, especially with the internet and selling on the internet, you'd want the national protection. And in terms of patents and copyrights, if you're an author and you're writing a book, you may not want anybody to copy that book, and so you go through the copyright office. Or if you're if you're a composer and you're doing some music, you want to go through the copyright office. And patent would be if you're doing something technologically, you're doing a new invention of some sort that you want patent. Those are ways that they're very specialized, but they can protect you against somebody stealing any of them across the country. Now, of course, if you're an international company, you may have to, and you're in London and Boston, you'll have to go to England to protect your marks there, because the US protection only applies in the US. Caution, though, is that people can make a small change to your patent design and say that it's not the same design and try to get around it. But it's still worth having. It does give you protection. Now, one thing that I would do if you have this type of property is I would have your employees agree that this is your property, that they're not going to use it, they have no ownership interest in it, that they're going to keep whatever the trade secrets or whatever it is confidential and not disclose them. So I would have, in the right context, the contractual protections from the employees. Now, the other contractual protection you want is if you have an employee who's working on, let's say he was working at Moderna, working on the COVID vaccine, you would want him to agree that his working on that COVID vaccine did not give him any ownership rights in the vaccine, that belonged to Moderna. So, he'd be an employee, work for hire, so that would be yours. You'd want that in the contract. I had one client who worked at a local Boston hospital and who developed something, and the hospital's contract said, whatever you develop while you're working for us, whether it's during business hours you're working here, whether you're doing it at home on weekends or whatever, is ours. And we'll pay you a royalty or something for it, but we own it. So these are the types of protections you want to build into your contracts to protect you from your employees saying it's theirs rather than yours, and to also keep the confidentiality and protection of it. Trademark, patent, and copyright is a highly specialized legal area. We have a colleague who's practiced law and did this his whole life, who's terrific, and we have referral sources that he can give you for that. But not your everyday lawyer is going to be able to do this necessarily. In some of it, like the trademarks, you may be able to do yourself without a lawyer. The last area I wanted to talk about a little bit is insurance. If you're selling something, you clearly want to get product liability insurance, so that even if I sell you the box of cornflakes and then you resell the box of cornflakes and they're tainted, while I, as the manufacturer, should be responsible, somebody's going to sue both you for selling the tainted product and going to be suing the manufacturer. So not only would you want in your contract the manufacturer is responsible, but you would want to have product liability insurance, so that if anybody gets food poisoning or is using a saw and the saw cuts off a finger or whatever it may be, that you have an insurance company coming in to protect you from any damages that were caused by that product. In any case, you're going to want to get a comprehensive commercial policy which covers personal injury and property damage, so that if you or your employees slip or have a customer who slips in your store, or who you damage their vehicle or whatever, that the insurance company will cover it, similar to what you probably have on your personal account. You'll also need workers' compensation insurance if you have employees, which will cover any loss or damage for injury incurred on the job. You may want to think about business interruption insurance. So for instance, in COVID, in COVID, you couldn't operate your business unless the insurance company excluded that from their coverage. If you had business interruption insurance, they would pay you something for the loss of business that you had during that period. Finally, key man policy. As you grow and your company becomes more valuable and you have partners, and if something happens to your partner and you have to either buy them out on a death or he becomes disabled and you need to hire someone to replace them, you can have purchased either life insurance or disability insurance on this individual. It is paid to the company and is used to pay out the estate of the deceased employee. So insurance is very important for any business you set up. And I'm sure you'll talk in the discussion on entities about the benefits of limited liability companies and corporations. I recommend both forming an entity in the appropriate circumstance and getting insurance, because while the insurance company policy will say, we insure you against this loss up to X dollars per accident, on one page, they'll have 25 pages of what they won't cover. And they're always looking at the won't cover to try to get out of coverage. But you also have to decide how much insurance you need and how much of a deductible you want. You have to assess the risk of your business. Like, what could happen? I mean, if you're selling chainsaws, it's probably a different risk than if you're providing accounting services. So you need to decide what sort of liability insurance you need in amounts, how much you're willing to bear yourself. That's the deductible. If you say, I'll take the first $2,000 of loss, I'll pay myself, you don't have to pay, that's going to result in one premium. If you say you're going to pay from $1, that's going to result in another premium. So you need to decide on deductibles and coverage levels as well. We're just at 1 o'clock or so. Do you have any more questions, Teresa?
Yeah, I have some intellectual property questions. Would a baking process that no one else does be a copyright if I don't want anyone else to start doing it?
That would be a copyright. The question, the problem with copyrights and everything is proving that nobody else this is unique, and that's where your attorney can help you out. But yes, that could be a baking process or formula. That could be a patent or a copyright, depending upon what it is. But the answer is yes, it should be protectable. But just remember, if your baking process says you bake the product for 4 minutes and 30 seconds, and then somebody comes in and says, in my process, I only bake it for 4 minutes, that's going to be different than your process. And so it's easy for people to change something here. It's like you say, I'm going to use a pinch of salt, and they're going to say I use a whole salt shaker. I mean, it's a different product, but the answer is it should be protectable. But I would talk to somebody in the field to see whether it's worth protecting, because, you know, it can be a big cost here. And the question is, how much protection does it give you?
Okay. Could I register my trademark, logo, or copyright abroad, for example, in Mexico? And would it be valid in the US?
If you register it in Mexico, you'd have to comply with Mexican laws, and I don't know what the Mexican laws are about copyright and trademarks. But that would generally just protect you in Mexico. You would have to register it in the United States as well. You know, these things are not international as of this time. They're by jurisdiction. So you need to have both Mexico and the US to protect it.
I have one last question that's currently posted. Business registration. I'm a lifestyle wellness coach registered in my city, but not with the state. Mm-hmm. My plan is to work with customers virtually. This involves group sessions. While I work from home, I may have participants outside of Massachusetts. Am I required to register with the state?
If you're registered with the city, it sounds like you're a sole proprietorship, because that's when you would register with the city. You don't have to register with the state. The only time you'd register with the state, well, first of all, I don't know I don't think you need a license to do what you do, but I check on that. That would be the state registration requirement, but you wouldn't have to register with the state if you're doing business as a sole proprietorship. You wouldn't need to do that. The question would be, do you need to qualify to do business in other states? And I think based upon the nature of your business at this point, I would not go ahead and do that. You know, you're located here, you're providing the service here, people call in from other states. I think that I would just leave yourself, you know, registered with the city as a sole proprietorship, or if you formed an entity, then you register with the state, but I don't think you need to do that.
Okay. We got through all the questions. So thank you everyone for joining us today. Thank you, David, for sharing tons of information. I reposted the locations for the recordings so that you can rewatch the recording. And again, you know, David's just touching the surface. Certainly, if you want to get involved into questions about your specific business, let us know. We have SCORE mentors that can assist you in our chapter and the other chapters in our district. And we're all happy to help you. So with that, I say good day to everyone. Thank you.